Good evening and welcome to another edition of My Take with yours truly, Joel Bhagwandin. This evening, I want to focus exclusively on the issue involving the recent High Court ruling in relation to the environmental liability obligations as per the environmental permit of ExxonMobil, its local subsidiary, which goes by the acronym EEPGL, and between with the government of Guyana. Now, before I get into the substance of the discussion, just for the benefit of the viewers, those who are perhaps joining this program for the first time, I want to remind the viewers what is the purpose of this program and what has inspired me to do this program. For the simple reason because there are so many podcasts, so many programs, so many virtual programs of this nature, radio programs, so many letter writers and commentators. And naturally so, because we're living in we're in the information age, the era of the information age. So the purpose of this program is essentially to bring a perspective on critical issues of national importance that relates to strictly public policy, public finance, economic issues, and other issues in political economy of national importance which affect all of our lives in some way, shape, or form. And as you, the viewers, would appreciate, there are all kinds of perspectives and opinions on various matters out there. So my intention and my objective is to deal with these issues from an evidence-based standpoint, from more of an academic standpoint, a critical assessment by way of conducting critical assessment and analysis, right? Not so much of the opinionated pieces and so on. So that is the distinction between what I do, what I'm seeking to do here, which complements my public writing as an analyst and a writer on these issues in the local media. So now coming to the topic for tonight, the topical discussion for tonight. As you would know, this whole argument for an unlimited insurance or unlimited parent company guarantee as such is a long-standing contentious issue that has been ongoing for the past 2 or 3 years since this government assumed office in 2020. And prior to the court ruling, I personally, admittedly, has never devote much attention to it because I felt that it was dealt with sufficiently. I felt that the ordinary person would understand that there is really no such thing as an unlimited insurance coverage. By simply getting an insurance coverage for your car, one would know, which we're accustomed to and which we know well, most households have a vehicle. You would know that there is no such thing as an unlimited coverage. And in fact, the value of that coverage would reduce over time as the value of that vehicle depreciates. The same applies to medical insurance. The same applies to whether you're seeking to get a fire insurance coverage for your property, right? The same principle apply in the insurance industry. It is no different. There is no such thing as unlimited insurance because risks in general, liabilities has to be measured. One has to be able to measure it. One has to be able to quantify it. And therefore, there is no way that one could quantify something that is unlimited or an infinite number. So that is the background of this issue, which resulted in the same group of advocates of that view ended up filing a court case, and which resulted in the ruling that we now have. And I want to read for you the ruling, and tonight I want to deconstruct this in an objective and an academic way, not the customary opinion pieces that you see in the papers. For example, since the court ruling to now, the media has been overwhelmed with views, and if you read all of them, they're all the views not grounded in any objective assessment or critical assessment. For example, today, there are too many to mention, but if I could mention just one, reference just one writer who happens to be the mayor or the outgoing mayor of the capital city. He says, he wrote that, this ruling, the government's position on the ruling, because the government through the Attorney General has publicly stated that they are going to appeal the decision, the High Court's judge's decision. And everybody is taking this to mean that the government is not acting in a transparent manner, and that this ruling is a landmark ruling in the interest of the country, and so on. So I want to establish at the outset, before I get into this exercise with you, that, and I said this to a politician in the opposition, who's part of the opposition. I said to him that, listen, this and a few other people, that this issue is not a political issue. This matter is a non-political matter, and you should not politicize it, because it is really a very technical issue, and no one has taken the time to examine the technicalities, to translate the technicalities, and to explain it so that the general public could appreciate and understand it. There's too much confusion about unlimited insurance coverage and parent company guarantee and a whole sort of different argument, but it is not grounded in any authoritative basis, not grounded in any analysis whatsoever. So let's now perform a basic academic exercise, or an elementary academic exercise, if I'm to put it that way. So I'm going to read for you some excerpts from the judge's ruling, right? I have extracted 2 paragraphs from the judge's ruling. Paragraph 6 of the judge's ruling states, the court found that ESSO was never in doubt as to what its liabilities are, as captured under Condition 14 of the Environmental Permit for the Liza Phase 1 petroleum production facility, as the stipulations were neither unusual, unique, or unauthorized. It was simply as a matter of law, fact, and consequence, the norm that prevails which bound ESSO as singularly and exclusively responsible for all liabilities without restriction implied or expressed from its operations at the Liza Phase 1 petroleum production facilities in the Stabroek Block offshore Guyana. It included all activities connected therewith as stipulated in Condition 14 of the Environmental Permit, extending to and inclusive of the transition to petroleum production operations and all activities incidental thereto. Paragraph 7 states, equally, the concomitant financial assurance obligations imposed on ESSO by Condition 1410 of the permit in the form of the environmental liability insurance, together with an unlimited parent company guarantee agreement, are but the legitimate corollary flowing from its uncapped and unlimited liabilities arising from an event and pollution as encapsulated in the permit, to provide such financial assurance in the form of insurance and unlimited parent company guarantees to cover its liabilities. Now, paragraph 7, emphasis on paragraph 7 is the key ruling of emphasis of the judge's decision, the key decision, together with an unlimited parent company guarantee, right? And what is important to note is that the judge relied to a large extent on condition 14 and specifically condition 1410 of the permit. Now I have with me here the permit. Now this, what you're seeing on the screen there, is condition 14 of the permit. Now let's read a few clauses from condition 14. It constitutes several clauses and subclauses. Let's just read a few relevant ones. The first clause states, 14.1, the permit holder is liable for all costs associated with cleanup, restoration, and compensation for any damages caused by any discharge of any contaminant, including the cost of all investigations into pollution incidents or discharge of contaminants conducted at the instance of agency. Now, specifically, the judge relied on condition 1410, where he interpreted that to mean unlimited liability or unlimited cap. Now, let's see what condition 10 states. Now, this is condition 10, if you could see clearly. Let me just show you back once again the ruling, the specific part of the rule. Equally, the concomitant financial assurance obligations imposed on SO by condition 1410 of the permit in the form of environmental liability insurance, together with an unlimited parent company guarantee agreement, are but the legitimate corollary flowing from its uncapped and unlimited liabilities arising from an event and pollution, etc., etc. Now let's read for condition 1410 verbatim. Condition 10 states, the permit holder must, as soon as reasonably practicable, provide from the parent company or affiliate companies of permit holder and its co-ventures one or more legally binding agreements to the agency in which the parent company or affiliate companies of permit holder and its co-ventures undertake to provide adequate financial resources for permit holder and its co-ventures to pay or satisfy their respective environmental obligations regarding the Starbuck block if permit holder and or its co-ventures fail to do so, and to so indemnify and keep indemnify the agency and the government of Guyana against all such environmental obligations. The key term or the key phrase here of note is undertake to provide adequate financial resources. Now, I'm not here to critique the judge's ruling, but to provide a different interpretation from a financial perspective as well, because this whole issue, has some financial ramifications, right? Now, the word adequate cannot be, you would agree, that the word adequate cannot be equated to unlimited. Adequate and unlimited has two very different meaning by definition. Adequate simply means that there is a limit. It implies that you have a limit. And there are other clauses within, which I don't want to get into too much of readings for you, but just to interpret to bring this interpretation and perspective. There are other clauses that speaks to estimates and reasonable estimates, right? So that's the first thing of note which I want to point out. This is the judge's ruling. This is the judge's decision. The decision was based on, or it was evidence that the judge relied on condition 14 of the permit. I've read the relevant sections of condition 14, specifically condition 1410, right? So that's the first thing. Now, So what really do we need? So what is the real contention of this issue? The real contention, or the bone of contention really, and why I say earlier I made the comment that this is not a political issue, is because it is a national issue, in the sense that as a country, the government of the day, the opposition of the day, and the people of Guyana, the stakeholders of Guyana, do not want the country to be exposed to any liability or to any environmental risk, that if there is such an occurrence, that we don't have to stand the cost from our treasury. That is the bone of contention. There is no dispute with that. There is no dispute. There is no contention in principle. So, but how do we achieve this? And this is what the former head of EPA, who has been the center of this, has been contending, Dr. Vincent Adams, that he has been asking ExxonMobil, parent company, to give a written guarantee, unlimited guarantee. And that has been his bone of contention ever since. And he argued further to say that there is no cost. All they have to do is write this on a piece of paper and put it on the company's letterhead, and the Exxon CEO signs it. But there are some technicalities. They can't just a guarantee. And now I'm delving into the financial aspect now, and hopefully I break this down. I translate it sufficiently so that the layperson could understand. In accounting and financial reporting, there are broadly two international reporting standards that countries adopt, in which companies have to adopt in their financial reporting, right? Now in the US, the standard, ExxonMobil is a US multinational company. And the standard that Exxon adopts has to comply with, rather, is called the GAAP standard. Okay? It's called the Generally Accepted Accounting Principles Financial Reporting Framework. And so when we speak of a guarantee, a financial guarantee, a guarantee is essentially a contingent liability. Now, what is a contingent liability? In fact, this entire environmental permit, where Exxon requires EEPGL, the subsidiary, the Guyana subsidiary of ExxonMobil, has to provide, one, an insurance coverage. Two, it has to provide, and the permit provides for this, it provides for a parent company guarantee. Now, the issue is not that the government is not seeking to get Exxon to comply with the parent company guarantee. The issue is, or the bone of the contentious problem is, that this guarantee should not have a limit. But you can't have an unlimited guarantee. And that's the problem that people don't understand. And these people are arguing, Vincent Adams and Kaicho News and the oil and gas, the folks from the oil and gas network, and Milandi Janki and so on. And this is what the judge is interpreting, which I show you unlimited can't be equated to adequate as the language used in the permit, right? So this environmental liability, which is a contingent liability, meaning it is to provide for a future event in case it happens. So it is not an immediate expense. So whether this guarantee is to the tune of $2 billion US, this $2 billion would not be reported on the company's balance sheet. It would not be an expense to the company. It would only become a liability or an expense if the risk becomes a reality. That is, if there is an oil spill. Right? So that is a contingent liability. It's the provision of a sum or guarantee undertaken by the contractors to Guyana that if this event occur, this is what we are going to cover the expenses. So I'm saying, having done all this, evaluation and examine everything together, the court's ruling, the environmental permit, have looked at the gap reporting framework, and so on. It does not provide for anything such as an unlimited guarantee. So, how then do we take care of that concern? And this is interesting. How then do we take care of the concern that on one hand we have the insurance, which is the insurance which is $600 million US. So we have the insurance coverage. So that is one aspect of the coverage. Secondly, as the Attorney General reported, that just a week before the court ruling, the government has managed to reach an agreement with ExxonMobil for a parent company guarantee to the tune of $2 billion. So we have the insurance and we have the parent company guarantee of $2 billion US. Now, if let's suppose, for argument's sake, that there is a spill and it exceeds $2 billion, does that mean that the country becomes liable? Does that mean that the government of Guyana becomes liable and we have to go to our treasury to foot the rest of the bill? And that is where the gray area is. And I'm saying, having done this analysis and this review of these things, my interpretation is no. Because if the reporting framework does not permit for there to be any such thing as an unlimited guarantee, the guarantee has to have an. Let me read what the GAP framework says in layman language. In accordance with the GAP framework, contingent liabilities can be broken down into three categories based on the likelihood of occurrence. The first category is the high probability contingency, which means that the probability of the liability arising greater than 50% and the amount associated with it can be estimated in reasonable accuracy. So that's the first category, where the contingent liability can be reasonably estimated. Not unlimited, you have to come up with a number. The second is a medium probability contingency, is one that satisfies either but not both of the parameters of a high probability contingency. These liabilities must be disclosed in the footnotes of the financial statements if either of the two is true. The third category, contingent liabilities that do not fall into the categories mentioned above, are considered low probability. The likelihood of a cost arising due to these liabilities is extremely low and therefore are not required to be reported in the financial statements. That's basically the GAP framework. And it does not, as I've read it in simple language, I've written it in simple language. It doesn't say that unlimited, you got to come up with an estimate. Even where it is difficult to come up with those estimates, the company is required to come up with management's best estimate. Right? So how do we take care of, if we have a spill, God forbid, what happens? Is the government of Guyana, will the government of Guyana become liable? No, because what is simply required is the insurance, the guarantee, and an undertaking. We need an undertaking from ExxonMobil to say that they will cover this, and this undertaking is already obtained vis-a-vis the environmental permit of itself. Why? Why am I saying that? Because I think I should show you this again. Let me just connect it. Let me just connect this. Now anybody could go on the environmental. Could you show the screen once more? Now anybody could go. You could go right now on the Environmental Protection Agency website and you could get a copy of the permit. This is a public document. Could you bring up the screen once more, my computer screen once more, the operator? In the meanwhile, let me read. I'm saying, no. So am I on live or? Oh, okay.